So welcome for this session of Webinars for Busy Lawyers. We are absolutely delighted that you could make it. I am Laura. I'm one of the law practice advisors for Mass LOMAP, which is part of Lawyers Concerned for Lawyers. This is one of the services we do, is these great monthly Webinars for Busy Lawyers, where we talk about practical tips that you can take away in less than an hour. Among all other services are free and confidential consultations. We also have an excellent blog full of resources. If you have any questions, please contact us later. For today's topic, we have legal billing, making payment plans pay off, which is wonderful because this is something a lot of people have been wondering about, and it's a newer area, and we're delighted to have an expert on the topic with this. Charity Anastasio is our speaker today. Oh, wonderful. Yes. Cheersmont, Maine. Wonderful. Thank you, Rachel. And I'm delighted to say that she's here for multiple reasons. First of all, Charity is just an outstanding human being. She is so smart, she is knowledgeable, she is very kind, and she's a great researcher and instructor. To give you a little bit of background about her, she is a practice and ethics counsel for the American Immigration Lawyers Association. She was in private practice for 5 years in the greater Seattle area before she entered the Bar Association world, where she has helped lawyers overcome their practice management hurdles for over 8 years. Charity is an enthusiastic ethics nerd and practice management ambassador. She advises on ethics and practice management issues through consultations, publications, and presentations. She is chair of the ABA Law Practice Division's Professional Development Board, is a past speaker at ABA Tech Show, and was named, this is very exciting, an ABA 2020 Women of Legal Tech honoree. You can find her on Twitter at Charity Anastas. So Charity, thank you so much for hosting. To let the audience know, we will have questions at the end. Please put them in the chat. But in the meantime, Charity, I will turn it over to you to learn about this great topic. And thank you so much for being here.
Thank you, Laura. Laura always makes me blush. She's very gracious. I appreciate it. That all makes me sound very exciting. So hopefully I can live up to that. So payment plans. You know, this is, you mentioned this is kind of a new area. There may be some things that are new in it, but really lawyers have been doing payment plans for a long time. And I'll kind of walk through what they used to do, what they're starting to do now, and some things that we might be able to do to fix it. But the first things that I'm going to start with is just what we're going to do today, which is we're going to cover how to lower or decrease the administrative burden and increase the income of those payment plans. And I'm going to specifically address some of these things, like knowing your payment plan methods and picking the best one for your firm, the different payment plan models and alternatives, and when really maybe we should be talking about process improvement or outsourcing instead of just the payment plan. But first, I'm going to give you my hard sell that payment plans really matter to your clients. That's why you need to be thinking about them. They really, really matter. In the 2021 Legal Trends Report published by Clio, which is something that they do every year, and they kind of change some of the questions that they do each year. But I think that this year, this one is a real standout statistic. 81% of consumers of legal services sought payment plans. 81% of people sought payment plans, and 50% of them said that it is a very positive influence of which lawyer they choose when somebody offers a payment plan. So it matters, right? It matters to certain types of clients even more. So we all know, we've all heard about the pro se problem, but we cannot ignore the fact that there is a large swath of people that are not getting their legal services helped at all because they don't have a lawyer. And often it's because they can't afford a lawyer. So 70 to 98% of the cases in America's civil courts have at least one client that is pro se, and sometimes both sides. We know that some practice areas are heavier in this than others. Family law, of course, to be one that you really usually is highlighted. And then another statistic, and I have my sources down at the bottom there too, is that legal aid organizations are turning away because they must 2/3 of the people that ask for their assistance. 2/3 of the people. And why is this? It's because America does not have savings, right? American savings statistics from 2020 show that 70% of Americans have less than $1,000 in their bank account. And really only 5% of them have somewhere in the ballpark of $10,000 to $20,000, which we know even small litigation can easily hit 10 to 20,000. So the bottom line is they don't have it in savings, and that's also their savings, often their retirement. So they have that earmarked for other things, other more exciting things like their new kitchen. And here comes along a legal problem, and they have to make a decision whether or not they're going to dedicate all of those funds to this legal issue or whether they're going to try and manage it themselves. It's not an easy decision, and that's why payment plans really matter to not just certain clients, but a large swath of potential clients. Now, this statistic is from immigration specific. I do work for American Immigration Lawyers Association, and this is sort of an informal survey that was done of just one of our chapters where they only had 24 responses there. So take it or leave it for what it's worth. But understand that potential clients may not be hiring you because they lack funds. And I think that this is a fair thing to just do some research in your own firm. You don't have to do it really technically. You don't have to, collect it through intense data research, but maybe for a month or two, just measure how many people come in as potential clients, do a consultation with you. And when they find out how much of it they either have to delay that legal work that they're going to do with you, do it themselves, or go and find somebody that is cheaper. Right? How many people do that? And note that in these 24 responses, over 70% of them said that they get 1 to 4 people that don't hire them because of finances. And that really adds up when you're talking about cases and your precious time, right? Because we know that when they do come back for a consultation, if they really like you, they come back for the consultation, you have to start all over again because enough has changed in their situation that you often cannot just pick up where you picked up before. They also might delay too much. So they may lose certain rights that they would have had an opportunity, rights of relief. And then, I just think it's also significant in this statistic that not one of them said they lose 0 clients per month. And a good portion of them, 8%, well, maybe not a huge portion, 8% of them are losing more than 10 clients per month. That's extreme. That is another attorney in your firm, right? That really could be a whole nother associate working for you. I also want to recognize that lawyers can get burned on doing payment plans. And I think that some of us are really, maybe not that enthusiastic to do them. And there are good reasons for that. They are labor intensive to invoice. They have to be done on a regular basis. Lots of clients will need nudging. I always think of the movie of the Lincoln Lawyer when they're like, I have no money, I'm not getting paid, it says his office support. And he's like, well, what do we need to do? And we need to start making the calls. We're going to call everybody. Come on, give me money. You owe me money. And they go through this whole process and they have cash flow problems that go up and down on a regular basis because clearly this happens on a regular basis. Now, I know most of you are not that bad as the Lincoln Lawyer, but I do recognize that generally, if you're doing payment plans, clients will need nudging. Clients also lose their jobs and need adjustments to those payment plans, which can also be labor intensive. You have to process the payments, which if you're not doing best practices may also be labor intensive. And then I think that there's also, I'm just going to acknowledge that we do to a degree fear asking for payments. Right? We don't want a malpractice action. We don't want a bar complaint. Sometimes when we don't get paid, we just go ahead and write it off. And some of us are really adverse to money issues. So how do we make it better? How can we incorporate this thing that we know probably about 80% of the people that are going to come to us want, without sinking us, without really sinking our business? I was pitching to Laura when we were sitting on before you guys came, that really lawyers are lenders. They often are financing people's cases at 0% interest for the duration of the case, right? And they're often not asking them anything about credit worthiness, not asking them what their income is, whether they have enough money to actually pay that bill or that payment plan that they've set them up on. So I'll just pitch to you that if you really want to be a lender, I support you in it, but consider whether or not it's the best way to do this, because we can learn from other institutions and other disciplines. And there is something to why banks and credit unions require a certain amount of credit worthiness. Understanding what folks' income is and actually asking them some proof of what that income is. And I do understand that many of us have clients that are lower income, and that we actually want to serve them, and we're working ourselves, or we're working our tails off to which may be a good thing as we come into Thanksgiving. But we're working very hard to really have a low overhead and to reach those clients that are modest means or moderate means, because as we acknowledged earlier, 2/3 are getting rejected by the legal aid. They still need help. There's a big swath of people that are really potentially great clients. You could have a sliding scale as well. And maybe that sliding scale of fees says, with this debt to income ratio, this is how much you pay for my legal services. But you still could say, but show me that you can pay that amount. Let's make sure that we set up a payment plan that actually is going to match how much you can reasonably pay per month. And I propose to you that maybe we could just call this good client selection, right? We're doing a little bit of a process of good client selection. And you can ask for a credit check. You probably want to make sure that you have some kind of agreement with them. You're not going to do it without their permission, but you could say, I want to see your income and I want to see a credit check, just to verify that this payment plan is going to be one that is really going to be that you're going to succeed at, right? This may be too beginner for some of you, but I'm going to say it anyway, because every once in a while I run into an attorney that just doesn't have this in place. And it's essential, if you're going to have a payment plan work, that you need some processes and procedures in place so that it does work. So first order of business in that process is capturing time. The more contemporaneous this is done, and the more technologically it is done, the more likely you will get paid if you were an hourly attorney. And I know that doesn't matter to all you flat fee people as much, unless that representation ends before the whole scope is done. And the scope of representation, you have to prove that in quantum merit claim, and then that time capture becomes very important. But having a process of capturing time and making it as contemporaneous to the time capture as you can is the first step. And then drafting the invoice. Now, if you're going really non-tech, you can do this with just a spreadsheet. And it could add things up automatically, so you still got a little automation in there. But it is made easier if you're using technology like a case management or practice management platform to capture the time, and then automatically generating the invoice from that information that has already been put in. Saving time is one of those places where you can streamline the process and it will improve the process. Then the lawyer must review that bill. It shouldn't go out by an assistant without a full review to make sure that all of it is accurate. And often firms that do this will have the support staff create everything, the bill, when we used to do it in the old age, in the snail mail, putting the envelope there, and then the lawyer would review, the stamp would be on, and they just pop it in there and send it. And then you know that it is accurate and it has gone out by the lawyer's hand. Now you're going to get paid quicker and probably be more in the norm if you're doing this by email or text. And I'll talk about that a little bit later too. And then you send that bill, and then payment is due in a certain period of time. I had a very sweet attorney ask me once. She said, I give them a month and a half to pay the bill. Why are they not doing it yet? Like, I don't understand what I have to do to get payments in from my clients. And I said, I think the issue is you're giving them a month and a half. There's no sense of urgency to that bill. And you can say that that bill is due upon their receipt when they get it, or even give them 2 weeks. And that is plenty of time. That is the norm, right? Stick within the norm of what businesses do, because if you give them a month and a half, they forget it. You don't want them to forget to pay the bill. And then have a collection procedure. And this isn't just for attorneys that are actually going to fight when somebody doesn't. This is for everybody. You need a collection procedure because you need to make sure you realize as much of the work that you have done, that income for it, as possible. The collection procedure could be first a call to the client, right? And that call could be done by an assistant or a support staff or a bookkeeper. And then maybe checking, we already have them on payment plans, but checking whether the payment plan works for them anymore, right? Are you still employed where you were before? You're not. I'm so sorry to hear that. You're looking for work and you're on unemployment. Okay, well, let's cancel 2 months of payments, and then we're going to reinstate the payment at this time. If you're not able to do that, you must contact me. Or maybe you spread it out, smaller payments over a shorter period or over a longer period of time. Then if they still continue to not pay on time, you probably want to do something more formal. This is where you maybe would do the snail mail, because you could have proof of receipt. And I do think you want to document all your actions that you're doing here. And then maybe you escalate it by doing a call and a letter to the client saying you will be receiving a letter. That letter says that if you don't pay me this time, because this is your third, late payment, that it will be withdrawing from your case. I really don't want to withdraw from your case, but unfortunately, that is going to be where we're going to be going next. Do you understand? Following up with a letter so that it's documented, and then do consider collection. I know that we are afraid about it, about doing it. I do think, though, I have some attorneys that they said, I did the work, I did it very well, and I have proof that I've done all of the right steps. And the bottom line is, I think I should be paid. And even if they do bring a complaint, that's one of the reasons why we document what we did, all the work that we did on the case. And then we also document all the work that we did to try and give them an opportunity to pay kindly. And then eventually maybe you do it. But I am a firm believer too, that the person that is their own lawyer is a fool, right? And this works, I think the same way. I would have somebody else do the collection. I would pay somebody to do it, so that you're not feeling like, oh, and here I am again talking to them, which is frustrating, right? Charge the right fee for the right work. And I would probably add to this, at the right time, right? Most legal fees are one of these four. Flat or fixed fee is in certain practice areas more than others. Criminal, some family matters, some estate planning, some immigration, and then it's not in other ones, but it still can be set on a payment plan. There's no reason why you can't do a flat or fixed fee on a payment plan. You're more likely to get that full fee if you do it in bigger amounts and fewer ones. So the statistics show that if you charge $3,000, one $1,500 fee and another $1,500 fee, that's still a payment plan, but it's in these big chunks. You're more likely to get those two big chunks than you are if you split it out into 300 for however many months. For, well, 3,000, that would be 10, right? Am I doing my math right? So just think about whether or not this is a good fit, but don't rule out payment plans of some form with fixed fees too, because even those big chunks can be hard for people sometimes. Hourly can also be done on a regular basis. It usually looks like a retainer, and then maybe an evergreen retainer is what many attorneys call it. They'll say, we're still working on your case. This is your invoice for the work that we've done. As you know, this is not a bill. We take this out of what we have in our trust account. However, the trust account balance is X. Maybe you have a certain point where it gets below that point. You make sure that you're going to charge, you're going to notify them they have to re-up. So maybe it's 200, though your balance in the IOLTA account has hit, and you probably don't call it an IOLTA account with the client, but I'm trying to think of that language on the fly here. Balance on your account is $200 or fallen below $200. So we're asking you to re-up. Please send us a bill, or please send us a check for $1,500, whatever the re-up amount is. And then sometimes it is just every month you're going to pay us $300 for work that has already been done or is in the works. I think it matters sometimes where you put it in the trust account, and that's probably deeper than we need to get today. But if you have questions about it, you do have my contact information on that first slide. And then hybrid is some combination of usually flat fee and hourly. Classic example of this is I'm doing your case for a flat fee of $3,000. That includes everything except for a discovery request, or except for a request for evidence. And that will be done on an hourly basis at this rate, and you'll need to make payments this way. And the reason why we do that is because that's the uncertain component, right? Flat fixed fee, good for the certain component. Uncertain component, you need to make sure that it's hourly, or that you have enough of a sense of how much time it's going to take that you can do it. And then the contingent fee is a little bit, people will think like, what does that have to do with payment plans? But I do see some lawyers with contingent fees that are going to come in based upon whether they win or not, but they may put their client on a payment plan for the costs of the case, right? Because some attorneys that are doing this type of work will actually finance that client's entire case and take all those costs monies back. But that means the lawyer has to have a line of credit or a savings for it. And that may not be the best option. And instead, what you could do is you could set them up on a payment plan for the costs, which still could cost $300 a month for a good, year or two. But then you just have a system for making sure that money does come in. And it does sometimes solve some of your cash flow problems, because if you have a number of people on payment plans, it's going to stretch out that money that you get for them. I think it's sometimes hard too, though, to feel like you have to wait, right? So you might still have cash flow problems as you start, but you have to get enough people on payment plans that it sort of solves that. This is maybe obvious to people, but it is important. Software like Clio, Harmony Legal, few other softwares that really have thought about this. It's easy to change people's payment. So if you do have to cancel those payments for 2 months, they're not going to automatically get the notice. And then maybe you can even adjust how much the payment is really quickly instead of having to work through all the math yourself again. Use the tech that you have available to you. Understand how to do this so that you're not manually doing it, because it costs you money when you manually do it. And don't forget to put questions in the chat, because we will come back around to all of them. But let me know what slide it relates to, of course. Automating payments. This is, I'm going to check my time. Okay. This is really super important for getting paid faster and making sure that the funds are secure, right? But I think I'll highlight that you want to keep your fees down. And that's why I have ACH, which is automatic deduction from individuals' accounts as as an option there. That's like what many of you have set up for your insurances, right? Your insurance provider or your uh, my life insurance, my car insurance, all automatically deducted from my bank account. Very handy. You can do the same thing. It's lower fee than a lot of the credit card processors. And it does require sometimes that you do something each month to make sure that it goes through. They can still cancel that. They can still put a hold on it with their financial institution saying, don't pay that person, just like they can with their credit card. But I think it's a nice direct line, and some attorneys that I know, especially ones that have really leaned into the payment plan on credit cards, are finding themselves with a lot of fees. And you have to figure out how you're going to pay those fees. You can sometimes pass that through to the client in certain jurisdictions, but you want to check whether your state does or not. And even if you can't directly do it, you could just increase your fee, right? Your flat fee or your hourly rate could be increased to cover that. But it's whether or not you want to do that to your clients, or whether you think that part of what makes you competitive is that you're working really hard to keep that fee low and your overhead low. Because this is overhead. And I talk to attorneys that run into, oh boy, I'm looking at 500,000 in credit card fees this year. I got to come up with a solution. I put Square and Stripe at the top there. Those ones are good. I think they're easy to use. They often are lower fee than some of the other ones, but I'll warn you that you want to be cautious about having them go into a lawyer trust account, because if you do have a chargeback, you have a client that says, oh, I don't think I want to pay that person. I know she did all the work, but it's been 3 months and I think I'm just going to challenge that payment. Those merchant accounts usually pull it directly out of the account that it went into. Not a problem if it went into your operating, but it is a problem if it went into your lawyer trust account, because that's other clients' money. And they're probably not going to check the balance, right? Hopefully it's other clients' money. If it's not other clients' money, it's putting you in the red, and then you're talking to your bar about why your account went with insufficient funds all of a sudden. And you have proof of why, but it's still uncomfortable. So LawPay and LexCharge are the types that understand lawyers and that it's going into a lawyer trust account. And those are the ones that you probably want to look at if you're using the lawyer trust account in order to do some of this work. And I put both of them up there too. A lot of people don't know about LexCharge, but they really are pushing into the market because they feel like LawPay has too high of fees. But I got to say, LawPay has been around for a really long time, and they really understand lawyers. If you have a lot of billable hours, if you have a lot of money coming into your account, you're going to have a better rate with LawPay than you do if you're tiny. But if you're tiny, you're going to pay a higher interest rate. So all these kind of come into, what am I going to pick now? I put Venmo there too, because I think there's some processing that is going to happen through some of these new applications. And I think you can't take things like that. I think be careful with using it when it's going into a lawyer trust account. Maybe get a bar opinion, but again, keeping the fees low, automating the payment is a way to go. And if you have a young client base, they might be interested in that. Whew, boy, I do talk fast on these, don't I? So another really important thing, and especially if you're somebody that goes, oh, I hate the money, but I know I have to understand it all. And I stay up late and I do this late at night, or I do this on Sunday. I reconcile all my books, or even worse, I haven't reconciled my books in 8 months and I don't want to admit it to anyone. Hire where you need help. Hire somebody that knows how to do this in 2 hours where you do it in 8. I know it costs like 150 an hour for them, but you are more than 150 an hour, hopefully. And you need to make sure that you're using your talents where you are talented. You do have to understand everything they say on that. And when they do that reconciliation, you need to review it and you need to get it. And you need to make sure that you approve of it and where you understand all the different accounts, but hire. It's it's usually you can outsource this to somebody, talk to some of your local colleagues, because you usually want somebody that is local. Well, maybe not. I mean, there's a lot of different good companies that do this. And then consider financing. Now, I started with saying, look, you've been financing clients' cases. If you're doing payment plans at 0% interest often, sometimes the question comes in, can I charge interest? You probably can. You just want to make sure that it's within the usury amounts that are appropriate. But again, I'm telling you, maybe this isn't your best skill set when it comes to bookkeeping and accounting. It might not be your best skill set when you're looking at money too, about whether or not that person is credit worthy, whether or not they're a good client for you. In demeanor and nature may be easy to identify, but whether or not they're going to pay you, maybe it should be done by somebody else. So I have a few options here. You'll get a copy of these slides, which they are hyperlinked. I set the first three off to this side because they're for profit. I qualify lending. I got to look at my notes here. I qualify lending. Great, because it's in all 50 states. It does 10 practice areas. And I think they're going to be a higher interest rate than what you're used to. But remember that they're often qualifying people that don't have credit any other way. And you can't always tell your clients, like, look, go to your credit union, see if you can get a line of credit or a personal loan to do this work with me. But you could say, this financer understands legal services. Maybe you go through them. The other thing too is iQualify has a collections. You can outsource your collection process to them, and they can actually do that work for you. So they kind of have two things that they're doing. FlexBuy, also for profit, 50 up to 50K for what they're going to lend to. They do as low as 5.99% interest, which is pretty low for loans of this nature. In fact, they're really low. And then they promise to pay the lawyers within 72 hours of that person qualifying, which I think is pretty great. Law pays client credit. So this has not launched yet, though they've started to do press releases on it. I think they're still working out the terms. I think it's probably going to be popular because so many of you use LawPay already, and you know that they understand lawyers and the law. But granted, they're new to it, so I'm not certain that it's going to be great. It sounds like they're going to do between 150 and 17,000. It will be the top loan. I suspect they'll be all 50 states. The reason why that's an issue is lenders have to qualify state by state, and some states are harder to qualify with than others. I feel like LawPay is like big enough on the scene that they will probably be in most states, though, if not all of them right away. And so it's a few months away if you're interested in that one. Justice for Me, also on this side, but down at the bottom, is an interesting one. I believe it's a nonprofit. It came to my attention in one of the tech show startup alleys, and it has actually been busy, even though I haven't looked at it in a while. They do 32 different practice areas. They do up to 50,000. Their interest rate is 15%. Remember, customers who are not qualifying for loans at their bank are coming to them. They have to make sure they cover however many people do not pay, and if they have to collect from them. It does require invoicing them, which I think is kind of a downside because it means you still have that administrative burden of the invoice, but you have that guarantee that this person has been approved for a certain line of credit. And it's kind of good for the client too, because it's a line of credit. It's not going to be used until they use it, right? So they're not going to have to pay any interest on anything that you haven't billed to Justice for Me. And then they only have that certain amount. So you know exactly how much you can bill them for, and you got to talk to the client if you start getting up to the top. They're in 25 states, so half of the states across the country, still working on ones. And what's interesting about them too is they have a find a lawyer here. They started in Texas, so I think most of the lawyers are in Texas, but people can actually find a lawyer through them, get the financing, and then contact you, which is kind of interesting. Now, the three over on this side are more, because remember, I do immigration, help immigration lawyers. So I'm paying a special attention to the ones that are immigration specific. And I'll highlight Capital Good Fund, which has really been making efforts to enter more of the different states. They're in 8 states now, and I expect them to be in all 50 or nearly 50 within the next few years. They have an interest rate, used to be 12%, but they just got a grant to lower it to 7%. They will only lend to people that are looking for immigration work, but they fund up to 20,000 on a case. And you know, the thing that makes them really exceptional, I think, is they're going to qualify people who can verify income, even if they don't have a social security number, and even if they're just verifying by bank statements. So they do have to have a bank account, but they don't have to have a social, which is really important for immigrants, right? Because some of them are undocumented and they might be working under the table. They might have income, but they might not be able to qualify any other way. And then the mission asset one is kind of unusual in that it is for pro bono clients who can't cover the costs of their case, and they're usually pretty micro loans, but they're for people that that just can't cover the costs of whatever case they have coming up. And the Federal Credit Union, very limited offerings, but they do specifically loans for DACA recipients and for naturalization. The only downside is they're only doing 800 for DACA and up to 1,000 for naturalization. So yeah, it's kind of hard to find an attorney that can always do that case for that little. But worth noting, right? So everybody always goes, oh my God, there's ethical problems with financing. And there are, right? There are potential ethical issues. I think that the biggest one is just to note that 1.8 model rule 1.8E says a lawyer may pay court costs and expenses of litigation on behalf of an indigent client. I put indigent in, but you can put whatever, low income or whatever you want. But it's my belief that a lawyer shouldn't be funding all of her clients' cases or his clients' cases. So it's worth considering the potential conflict of interest. And I say this because I know what it feels like to have a client who you're working your tail off for and they stop paying. And you're like, I am the only one on your case. I can't withdraw because it's too close. You're not paying me. And they're like, I can't pay you. And they have the newest phone and a beautiful bag, and they seem to be paying their car payment fine. And I would just propose that conflict of interest is worse in some ways than the conflict of interest that you get from figuring out whether or not the lender is going to be fair to this person. It's not our job to make sure that a client gets every deal fair. You can give them a few options. They can go, not everybody's going to qualify. That's just the truth. Not everybody's going to qualify for a loan. Some people are not credit worthy. Some people do not have co-applicants that can make them credit worthy. But you can give them some options to give them the best chance, right? And then it pulls you out of this issue, because remember that 1.7, which is your current conflicts of interest or client one, is not just about conflicts of interest with you or with a client and a client. Another client, and 1.9 is for past clients. It also is for the lawyer themselves. So a lawyer shall not represent a client if the representation involves a concurrent conflict of interest. A current conflict of interest exists if there is a significant risk that the representation of one or more clients will be materially limited by a personal interest of the lawyer. Now I'm cutting out all that stuff that's about other people and just saying, ask yourself whether your representation becomes materially limited when that client stops paying. Because I know for me, it was hard. And I know for a lot of other lawyers, it's really hard to keep working on a case when you know you're not getting paid instead of already being paid, right? So you can keep on representing the client, and I have the language there, but it means that you have to rise to this. You have to rise to this test. Right? You have to believe that you can provide them competent, diligent representation. The representation is not prohibited by law, and the client gives informed consent in writing, which means that you would have to talk to them about that bill again, right? you'd have to talk to them about the fact that I'm working for you and you haven't paid me in a long time. We need to know when you will. So I know I said not everyone will qualify. And that's on the financing end. And not everyone qualifies as a client for you, right? If we're taking every client that comes in the door, we're probably not doing good client selection, because sometimes clients aren't a great fit for us. They have expectations of, 24/7 availability, and that's not really how your firm works. Or they don't actually have enough finances to pay for the case. That's just a couple examples, right? Maybe they have a demeanor, or they want to do a certain course of action that you're like, I've advised you against this. Those are clients that you can turn down. But also, your business needs to be on firm ground. I want it to succeed. You can't help anybody if your business doesn't succeed. But if you find yourself really pained by this idea of not everyone is going to qualify, and some of these clients being told they don't have enough money to hire you, just consider maybe changing your course or even your entity. Look at the nonprofit world, consider whether or not you could change yourself to a nonprofit and seek grants to pay for their work, or maybe move towards legal aid instead of continuing to do what you're doing. Because I I understand it. And so don't think that it stops there. You don't just have to suffer with that idea. And here's where I shamelessly use cute pictures to hopefully instill your good graces and say thank you, and open it up to questions and answers. There's 10 of you, there's got to be at least one question.
Charity, that was absolutely tremendous. Thank you so much. I know I learned so much. I'm sure that the other attendees have learned so much too. I want to, as we have people, if you have questions, put them in the chat. In the meantime, I want to review a few points that you made that I really think were so key for this. First, about that it's not only a huge need, but a huge demand from clients. About 80% of clients want this. 2/3 are getting rejected from legal aid. Where Americans have such low savings, these are cases that if they could finance it out with payment plans, they would be able to hire more lawyers. I loved how you
Mhm.
talked about having the payment plan processes along with the collection processes, really needing to talk with the clients through the cases, which I know is something that is a struggle for a lot of people. You
Yeah.
noted about not ruling out payment plans for flat fee. I think that that's a great thing to note too, because those flat fees can be intimidating for some clients who really would like to hire you, but maybe they don't have that 5,000, 10,000, whatever the flat fee may be in the bank at the time.
Yeah.
Um,
And one point on that too, I'll mention is I do know some immigration attorneys who put somebody on a payment plan, and they say in their fee agreement and directly, you're going to pay this full amount and I won't start work until you're done paying it. And that is sort of a way to get somebody engaged in the process and ready to do the legal work, and setting them up maybe for a year of paying the firm and then start the work as soon as that whole pot is complete. The only issue that I have with that sometimes is, and this is one of the real clinchers about payment plans versus having that person go away and save until they can reach it, is that we know that many times in the law, there's a certain amount of unpredictability with delay, and there's a certain amount of just straight up, it's not the same case necessarily when they come back to you in a year or two or three, and that people don't always save well. So you got to look at your own practice area and your own client base and say, could they do this? Could they pay me? Do I have confidence that they're going to pay me for that year? I could put it away for them in the lawyer trust account until it's all there. And is the case going to be the same at that time? And that's a little bit of a guessing game. I know in immigration, a lot can change, right? With the ruling that comes out on Friday afternoon, it can change the entire case. And all of a sudden, when they come back a year later and they're like, we have all this money, you got to say, I'm sorry, but your case now takes double the amount of time because they've changed the regs. So think about whether or not that delay is too detrimental to the case at hand. not even talking about statutes of limitations, but what could happen. And the old fashioned way too, I didn't talk about this, but I do think it's kind of a fair consideration, is one of the ways that attorneys used to try to decrease the administrative burden is they would give people like a little, and lenders still do this sometimes, like a little check stub that give you the whole book, right? You ever had this in like student loans? They give you 30 of them every month. You pull it out and you send the check in with it, and then they don't send you a bill at all. That does decrease your administrative burden, presumably, but really evaluate whether your process is working if you're doing that, because I suspect that people still forget if they don't get a bill, right? And they're just going to pay faster and more accurately if you're emailing it or texting it to them, or if they have an online portal to pay. So, sorry, go ahead with your.
No, that is fantastic. I'm so glad you brought that up. I wanted to note too that I was so happy you brought up some different areas that lawyers can lower their overhead. You brought up ACH, which is those automatic deductions. E-checks also will have lower fees than credit cards. I also wanted to pick your brain, Charity, if I may. As I recall, some years ago, you had an article about what lawyers can do and write in their fee agreements for potential discounts for clients if the clients help some, and then conversely higher fees if the lawyer has to do more. Would you be willing to talk a little bit about some of those things that you can have also to try to decrease the fees for the client or decrease overhead for the lawyer?
Yeah, that's I appreciate you bringing that up. And I am an advocate of thinking about uh, what I've come down to is that maybe what you have is 2 or 3 tiers of service. And one of the tiers of service could be, because you do potentially have these clients who like to do things themselves, who are pretty bright, who have some interest in lowering the cost and being empowered and sort of self-sufficient to do certain things to themselves. And we call that limited scope sometimes, but it's not necessarily. You might still be doing everything. You're just saying these are going to be your responsibilities and they're going to be more than what, this is full service. This full service is at 10,000. This is limited service. This is the service where you do half and we do half, and you are a collaborator with us to accomplish your case, and you get it at 5,000, right? And I don't know if those numbers really make sense, but think about your types of clients that you have and look back at the numbers and say, now, Miss Smith, geez, she was great as a client. She got everything to me, and this is how fast her case was done. And Mr. Mr. I'm trying to think of something else placid. Mr. Smith was not a good client because guy was like pulling teeth and he was always late and it delayed all these things. And then think about having 2 different billing models for those types of clients and explaining to them at the outset, you could either be this type of client at this rate or this type of client at this rate. And if you think you're like the independent one, but you're not living up to it, we're going to have to move you sometimes to this one, and we will notify you in this way. And this can just be a really good way to engage the client in that at the very beginning of the best way to work with you, to give them an incentive to work with you in that best way. But it also gives you this totally clear, like they understand why it is they're paying more. And they've told you either, I want to be an elite client that gets Cadillac service, and that's where we need to be, or they have failed at the other one, right? And they tried, but they couldn't do it. And maybe you have 3. Maybe you have a middle one where it's like, I know you really want to be this way, but it's not working out. So we're going to move you to this plan, okay? But realize that you don't have to always commit to just one thing, right? One fee for everybody, because everybody's not the same, right? And some clients love to do their own work, and they almost battle to do it themselves. You're like, okay, go ahead, do that research. So I think most clients actually want full service. I think limited scope is only for a really certain type of client. You sometimes need different things for them. You need to teach them how to do things. And so you might need a different process for that. But a lot of the time, too, you can hire somebody to do that. It doesn't always have to be you. It can be a paralegal that's showing them the steps that they need to do and kind of like cajoling them. But the paralegal is a lot less expensive than you are. And so you can do it at a certain rate. Your business needs that data. Track your time and then measure it and look at what you could do. And don't feel like you're locked in. It was way more than it needed to be. You get me all excited. This is, yeah. Anyway.
I love that. And that tracking your data goes back to something you brought up earlier about to maybe do an informal survey for a month or two of people who are not hiring you, finding out, is it because they don't have the current funds available to pay right now? And about how many clients are you losing potentially? So I think
Yeah.
the more data you have on that, the better. And it doesn't have to be that formal.
It doesn't. It really could just be you or your secretary calling them afterwards and saying, hey, I really enjoyed meeting you. I sent you a fee agreement. You didn't sign it. I just wanted to check in and see why. Or, saying at the end that somebody says, oh, well, I'm going to think about it, and saying, I'd love to know why. I'd love to, be able to understand how I can help you more. And I'd be happy to work with you if it's possible. And just getting a better sense. They're not always going to be honest, right? They're not always going to be like, they might say, well, I think we're just not ready, when really what they mean is, I didn't like you very much. That's fine. But you get enough information, I think, that you could actually really understand whether or not you have some people who could be clients, but they can't because they're blown away by the price tag.
Those are great points. I see people writing in saying, thank you so much for the presentation, very helpful. I agree, this was absolutely tremendous, Charity. If people have more questions, please feel free, otherwise we will start to wrap up. I want to note too that one of the things Charity talked about today as a potential method for reaching out to your clients as part of your collections process is potentially texting them. This actually ties in. We have our expert next month. So next webinar for busy lawyers will be December 8th at noon Eastern. And he's from Connect. And Connect is a company that does text messaging for lawyers. And so the presentation topic will be about sort of an introduction to business reviews. If you haven't done a Google My Business, or have your business on Facebook, or you have done it but you want to know how to get more reviews on there, that will be the focus of the conversation. But the person also has a great background in having two-way text for clients, including about how you can text clients reminders that their bill is due. You can send links to the payment portal if it's a LawPay or LexCharge, or whatever you may be using. So those are great non-confrontational ways too that lawyers can do this.
Yeah, I think Connect is kind of moving into that space that ZipWhip left.
Yeah.
I'm sad that ZipWhip left because they were a great product. Yeah. Well, 32 texts a day is the average. Now, actually, that's from a few years ago. Average person does 32 texts a day. And that's averaging like a bunch of people who are old and don't text very much, and then a bunch of people who are young and text a whole lot. And I really think that if you're not thinking about texting, it's time, right? Anyway, it was a joy to see all of you. I know this is going to be, it's recorded and all my nerdiness is out there with my little things, but have a great Thanksgiving. It's good to see you, Laura, and good to see Rachel and everybody else.
Charity, thank you so much. This is incredibly insightful. Absolutely delighted to have you here. And for all attendees as well, thank you so much. Happy Thanksgiving, happy holiday. I see we're getting lots of more lovely notes in the chat. Thank you all for being with us. We really wish you the best. And thank you so much. I just absolutely loved this.
Good. See you soon.
Thank you.
Cheers.